And then y'all understanding that equity is thrown off. Y'all think everything is equity, 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 equity. Equity underlies, equity follows the law. It's not restrained by it. Equity does underlie every proceeding in law, and it will intervene when it's necessary. But everything's just not equity. Y'all learn a new word. It's like children. Y'all will learn a new word and just start saying it without any understanding of what you're saying. Equity is a beautiful branch of law. It really is. Yes, I got American jurisprudence on SPC University. I'm the one. Y'all don't none of y'all have it. Yes, we have American jurisprudence on SPC University. Okay, this is SPC University right here. I put a lot of money in this website, putting a lot of money back. If you go to our academy right here, we got PDF reading room. And right here, you will see American jurisprudence. And here are all the American jurisprudence. Yes, we have American jurisprudence on SPC University. Let me get back to this Georgia code, though. All right, I said, judge's duty to enter judgment for cause. Since the law allows the judge no discretion as to entering judgment, that's what let that word, you know, that word may. See, because somebody, they'll come in and just, see, they'll get on the internet and just read this, and they'll just read this and think they know what it's talking about. This is why they say that a person who represents himself has a fool for a client. This is why you go and you read, get to pull the book off the shelf and read the citations of authority to see how the judges interpret it. Because you are not the interpreter of the law. The legislature creates the laws, the executive enforces the laws, and the judiciary interprets the laws. Not you. You get down here. Costs are collectible by a FIFE. I got this from Gene Keating. Gene Keating was probably the last great white guru that y'all had. That was it. If you go and read the Gene Keating transcript, you will see him talking about a FIFE. It's called a fieri facias. This is the type of lien that they put on you. Costs in the criminal prosecution are collectible of the defendant by the levy of a FIFE at the termination of a prosecution if it finally results in the conviction of the defendant. Okay, well, what is a FIFE, man? Wait, what do you mean FIFE? What do you mean FIFE? Oh, here, what is a FIFE? What is a FIFE, man? What is that? So everybody that's guilty, they put a FIFE on them? I got Gene Keating hit me to this. See, I give credit where credit is due. I'll steal like all of you do out there. Y'all steal. Y'all don't understand what plagiarism is because most of you ain't went to school. You don't know what it is. Just plagiarize other people's stuff and don't give credit. So, FIFE. It's called the writ of fieri facias, commonly called a FIFE. You know what it means? It means you are the one, you caused it to be done, which commanded literally that you caused to be made was the early common law means of enforcing payment of a judgment. It was, in effect, an order to the sheriff of the court to enforce judgment against the debtor by levy, seizure, and sale of his personality to the extent needed to satisfy the judgment, executions, and enforcement. Okay, so this is it, fieri facias, right here, Latin. You caused to be done. It's your fault, but you will never understand that because your whole circle lacks 100% accountability. You're like these modern feminists. Y'all like a whole bunch of females. You don't take accountability for nothing. And that ain't the mark of a man. So let's keep going. I could keep going. I could concentrate. I mean, we got a 20-minute, this is like a 20-minute audio. I've only been into this 3 minutes. 3 minutes. This is why I didn't respond. Because I got to take my time out and do this right here. Wasting my time. Stuff that I've already researched 10 years ago. I'm giving you information I've been knowing for about the last 10 or 15 years. I've moved on. I'm doing offshore asset protection trust. We're going into a different space because most of y'all, really the reason, this is what is true, what they have said about y'all. They say that y'all are a collection of broke people. Y'all jobless. That's why you're upset. And they are absolutely correct. That's what I see. Because if you had some money, you wouldn't be doing these things that you're doing. You're broke. Let's just get to the brass tacks of it. You don't win. First of all, here's the next thing that y'all got wrong. You're looking for a win-lose scenario. I've told you to read Dealing with Presentments. Let's look at it real quick. I made videos on this. Y'all didn't watch it though. You didn't watch it. Y'all want y'all everything in y'all spaces. Can I get a win? That ain't what I taught. A win-lose scenario. When you go into win-lose scenarios with the government, you're gonna lose 99% of the time. Now, this is where acceptance for value came from, but y'all don't talk about that anymore. But I'm showing you right now it's commercial. I'm showing you, we got creditor and debtor relationships. Y'all go, oh, secure party bullshit. They just put a lien on somebody. What the fuck are you talking about? That's why you did secure party. It came from the fact that you want to put a already perfected lien in place before they do, because they put it against your property. That's why you're filing the UCC1. It don't have shit to do with none of that stuff that y'all are talking about, which is why I've never moved off of it. I have not moved off of secure party one time, because I know that stuff y'all teaching is bullshit. You have jurisdiction over me. Well, I'm a man of the land. We need to create a common law court. Who are you going to get to enforce your judgment? See what they just got with Anna Von Ritz on that tax case. You don't have to pay taxes. They're coming for y'all when y'all say that. That's the worst thing that you can do to the federal government. See, a lot of y'all ain't had any experience with the federal government. You don't really understand what type of animal you're dealing with. Until you get arrested, that's why you don't see any of these gurus come out and then keep teaching. Because they get a reality check real quick. I didn't need to go through that because I came from that out here and started teaching. Let's look at this real quick. This is dealing with presentments. This is probably one of the first documents I was given. It goes through legal fictions, what they are. It goes into the absolute. Dude whoever wrote this, he did have a good esoteric knowledge, talking about language and so forth. It is impossible to play the game when one does not know the rules. If playing the game with those who do not know the rules thoroughly, but have carte blanche to change them at will, and their bonds. I don't even understand why y'all don't read this. Y'all looking for the gurus. White patriots wrote this. These are some of the smartest ones y'all had. Y'all want to read them or nothing like this. You get down here, all loans are fraud, compensation, which is another word for set off, operation of law. What exactly is older in due course, which is UCC 3-302. You should know what that is. That ties into UCC 3-305 and UCC 3-306. Good faith, good intent, file release of interest. Where is this at? First notice, fair debt collection practices act. If a matter goes to court, blah, blah, blah. I got to get down here. It's on down here. It's on down here. When I was in jail, this is the part I had. I didn't have this. All this that we're going through right now, I never saw any of this until I got out. The part that I had in jail, because all this first part is civil. It doesn't deal with the criminal. This is what I had. Mine started here. So I was sent this, because this second section start with criminal, and this is 2003. And you can see we're dealing with bonds, bond for discharge, appearance bond, surety bond, case bond, performance bond, rules to the game. Fiction and real cannot mix. Public and private cannot mix. Stand out at all costs. There is no money. Do not participate in public controversy or public plays. It all has to do with trust, okay? Which was a very, very excellent explanation of when he talked about trust. And he gives a lot of definition of words. All right, but right down here is where you want to look at. Because he goes through a lot of definitions. He goes through this. He goes. This was a good section too, reading about the replevin bond and the bond. You'll learn a lot reading all this section right here. But construction, where is it at? Rules to the game. Is this it? Yeah, let's read this real quick. If the state cannot file a claim against you because it is a fictitious entity and you are a real man, y'all do that real living soul thing, then it must file a claim against a straw man to get to you. What is it trying to get? Does it want your body in jail, the money in your bank account, your house, your business? The answer is no. It wants your credit. It already has the rest of it because everything is either registered or found on registered property. The state does not want the things that are held in the name of the straw man. But it has no compunction against taking those things if you dishonor it in any way. All those things except your body belong to the straw man, which is an officer, agent, or employee of the U.S. or one of its states. They do not belong to you. The money, Federal Reserve notes, belong to the Federal Reserve because it is the entity that created it. The straw man just gets to use it as long as it follows the Federal Reserve rules. The title to real property associated with your house is held by the straw man. The business license for your business was issued to the straw man. The registration for the car names the straw man as the owner. The driver's license was issued to the straw man. None of these assets belong to you. They're all pieces of paper that belong to the straw man, unless it fails to follow the rules. The presentment has a complaint, a moving party. What is it trying to move? What is the complaint? It is usually used in a statute as the grounds for the complaint. If public and private can't mix, the complaint must be against the public straw man, not you. Why would the state care if a piece of paper violated a public fictitious law? What is the motivation? The state is trying to get you to let it use your credit. If you refuse, the state can move the court to grant relief from your dishonor. Does the state really have a complaint, or is it just asking for your help? And this is what gets into the Gene Keating transcript, which goes right along with this. Let me see if I can find it. Right here, he said, I want to start out by saying that to win in court, you have to know what goes on in court. What goes on in the courtroom goes back to Edward I. It's called the statute merchant. And what it is, it's a bond of merchant or bond of record. The statutes themselves are the bond, and what they do is duplicate the statutes that they charge you under with what are called a recognizance bond, and the people sign the recognizance bond without reading what the bond says. I brought this to Joe's attention when he signed his bond, and what it says is that you agree to pay back the debt when you go into court on a criminal charge. I ain't read none of this. This is Gene Keating. Y'all ain't read none of this. There's a book I call The Jurisdiction and Practice of the Law of Admiralty by John Hall. It's based on the clerk's praxis. This is how I found out about the clerk's praxis. Right here. Gene Keating introduced me to it. I went and got it. Took 6 weeks to study it. The clerk's practice, that's Admiralty. All of them talking about Admiralty. Not one of them have ever